Hi guys, welcome back. This week, one of you asked me if I would do a video about using recordings as evidence. I had a few recordings, but I won my case without ever having to use them. So instead of just me talking today, I thought that I'd introduce you guys to a member of our community, Court for short, who won her case in a huge judgment using her many incriminating recordings. As we listen to what she had to share, I'm going to add a few comments of my own.
So recordings are direct evidence. Direct evidence is what you want. You can have supporting evidence and all this stuff, but direct evidence, you can't dispute direct evidence unless you obtain them illegally.
Recordings are pretty great for situations where it would otherwise be our word against theirs. But keep in mind that illegal recordings may not be admissible and could even get you into some trouble.
So I went and did my own research, found out that Georgia was a one-party state, and that's what you have to be mindful of. Just do the research in your state. If your state is a one-party state, all you need to do is be a participant in the conversation. Meaning you don't have to tell anybody else in the room that you're recording as long as you are involved in that conversation. I mean, recording while you're in the room and different things like that, totally legal in one party state. The only person that needs consent is one party in the conversation, and that was me. But if you're in a two-party consent state, you need to tell the people that you're recording or get their permission, blase, right?
In addition to the law, some employers have policies that restrict recording. And the key to getting around that obstacle is all about how and when you let them know that you have recordings. Both Courtney and I saved our recordings for fairly late in the process. In fact, I never had to use mine. And I'll let Courtney tell you how she used hers.
So in the informal stage of my complaint, I didn't tell anybody anything. But what I did was just like you, I kind of wrote it out, the parts that I thought were meaningful, right? And I wrote that out, quoted it and everything, right? It wasn't until I got my ROI, requested a hearing and initial conference with the judge, and then discovery. When discovery started, I was able to upload my recordings, and that's when everything started looking up.
Even though I never used my actual recordings, I did create transcripts, and I used those during my investigation and discovery. I never mentioned that I had actual recordings, but my transcripts were verbatim, so I'm sure some of the officials who were involved in those conversations were well aware. Here's how Courtney did her big reveal.
I think I told you that when I was in one of my settlement conferences, one of two, my judge did an amazing job, and he knew the case, and he took the time. So he played one of the recordings. One of the 13 incriminating recordings I had. He played one of them, and he asked the agency counsel, he was like, how do you guys plan to defend this? Because this is essentially direct retaliation or, discrimination. And then she made up some stuff like, oh, the person that said that didn't have the authority to say that. And he was like, okay, but it was said. How do you guys plan on defending this? Because if you guys don't settle, we take this to a hearing and it's found that this is discrimination, she will get back pay. She will get blah, 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 blah. Basically, exactly what he said was going to happen happened. And they knew it was going to happen at our first settlement conference.
Depending on your situation, you may actually want to use your recordings during settlement talks or mediation. If your employer is already motivated to settle, then letting them know that you have recordings can give them that final push. On the other hand, if they're coming in with lowball offers and still casting shade on all your claims, you may want to wait a little while. I recommend talking it over with an employment attorney before you decide. And recordings can also be useful at summary judgment, where we can use them to prove that our employer's version of the undisputed facts is very much in dispute. Here's how Courtney used her recordings.
We were about to go to hearing, and we were prepping for the hearing. So to save money and not to have to hire a legal professional company, I transcribed it, right? I had to submit an affidavit of what the recording was about. I went through and I did the hard work, and I listened and got re-traumatized over again, but I saved money because we didn't have to have someone else do it. I gave the key parts rather than doing the whole things with the minute marker, who said what, blah, 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 blah. And how that was used in the hearing was it made it easy for the points that we needed to draw out. So when we submitted the whole recording, used it as an exhibit. They were marked for, yes, this is relevant. So we're going in through a hearing. My lawyer's asking his questions. And then when we pull up the exhibit, he'll ask the judge, who's like, hey, Your Honor, can you pull up exhibit X? Can you start playing it at the 2-minute and 13-second mark? And can you play it through 2-minute and 52-second mark? So he plays it. Then your lawyer proceeds to ask the questions about what it is that he just played. So how mine was used was kind of like, is it true that you said this? And they'll be like, I don't recall, or no, I would never say that. Or he was like, so you're saying that you've never said, I ain't no. That was one of the questions. So you've never said I ain't. And she goes, no, I would never say anything. I don't talk like that. No, no, no. And then he asked the judge, he was like, Your Honor, could you pull up exhibit, whatever, and play the da-da-da? And then it says it, and she just looks defeated at this point. This was actually a piece of evidence that we used for impeachment. We impeached the supervisor so many times. The judge deemed her entire testimony not credible.
I wish I could have been in the room when that happened. Courtney has an awesome story, and I hope before too long we can share more of it with you guys. Like the rest of us, she has learned a ton from going through this process, and she seems eager to share, so fingers crossed. And there's one other thing I want to share with you guys today. It's a video by Vincent P. from an employment attorney's perspective about how and when to use recordings. It's pretty clever. You guys should definitely check that out. So that's what we've got today, guys. I hope that some of this has helped you figure out how to use your recordings to your maximum advantage. And like I said, if you have questions, drop them in the comments and somebody will answer them. I'll see you guys in the next one. Till then, take care and hang in. Bye, smart.